I might as well start. So good afternoon, everyone, and thank you all for coming. My name is Mark Holloway. I am a cost lawyer with Pagan Web and chair of the Junior Lawyers Division. Today I'm representing the BLS and chairing this webinar. Today's webinar is on personal injury, and we have three fantastic barristers from St John's Chambers. We have James Hughes, who will be speaking on fundamental dishonesty, John Lindfield, who will be speaking on mistakes about costs, and David Forster, who will be speaking about care and assistance claims. There are a few little bits of housekeeping I just want to touch on before we pass over to James. So everyone's aware this event is being recorded, and the recording will be released after the event has finished. And also the slides will be released afterwards as well. So there's no need to scrabble around trying to write down every little bit. You will be given that information afterwards. And just so you all are aware, there is a Q&A and chat box function at the bottom. We recommend that you use the Q&A function, not the chat box. The Q&A is anonymous. And then at the end of this, we will read them. I will read them out to the speakers, and then we will run through the Q&A. We have each speaker has 15 minutes, and we have a 15-minute break at the end for Q&A, and the event is due to finish at 2. So after that, I shall now pass you over to James.
Good afternoon again, everybody. I'll try again. So 2 introductions for those who were here already and heard me introduce me and my colleagues. So I'm going to be talking to you about the fundamentals of fundamental dishonesty. And for those who didn't catch the first 2 of my slides, why does it matter? Why does FD matter? Well, 2 key reasons. You can use an allegation to secure a dismissal of the claim under Section 57 of the Criminal Justice and Courts Act 2015, that should be, not 1957, and secure the recovery of costs from what would otherwise be a claimant that we know is protected by quocs. And I touched upon, for those that didn't catch this slide, what the rules say about what fundamental dishonesty is and its effect. And you've got the content of CPR 4416 there. Orders for costs made against the claimant may be enforced to the full extent of such orders with the permission of the court where the claim is found on the balance of probabilities to be fundamentally dishonest. So that's in short, and you've got, I'll leave you to read, you've got the slides after this webinar, the other parts of that section, but in short, where the claim is found to be fundamentally dishonest, then with the permission of the court, the defendant typically can ask the judge to enforce orders for costs to the full extent of those orders. Section 57 of the 2015 Act, I've set it out for you there. The essence of it is that the court, if it finds on an application for dismissal of the claim for fundamentally dishonest, if a claimant has been FD in relation to the primary claim or related claim, then the court dismisses the whole of the claim, but will allow the claimant a discount as to the order for costs against the amount of damages that it would have awarded. And you can see then that why FD matters and its effect, that where a claimant would have otherwise had quocs protection, they or a claim who is brought for the benefit of a claimant, that is to say by another, usually the executor of an estate or a litigation friend, will have an enforceable order for costs against them, and they can be committed for contempt of court if FD is found. How has it been defined? These are the key cases. Gosling and Halo, the first one, a decision of His Honour Judge Maloney QC, where he found in the sitting as a circuit judge in Cambridge. It's quite an old decision now, it's 2014 decision, but it's the starting point as to the definition for fundamental dishonesty. It had to be interpreted purposively and contextually, he said, and the fundamental dishonesty provisions of FD determined whether the claimant was deserving of the protection extended for social policy reasons by the Jackson reforms by Quox. And Judge Maloney said if the dishonesty went to the root or the whole of the whole or part of the claim, then that would be fundamentally dishonest. That prompted the addition by Section 57 of the 2015 Act, because you'll see there's reference to the whole or a substantial part of the claim that would be fundamentally dishonest. Gosling was a case about a claimant who'd suffered a serious knee injury requiring arthroplasty after he had had an accident with a ladder manufactured by D1. He said that 3 years later, the ladder having been sold by the second defendant, D2, he said that the accident was caused by deficient construction of the ladder, but the defendants got surveillance of him and it showed him shopping at length one morning without using a crutch, but then using a crutch when he went to go and see the defendant's experts. And Judge Maloney said that was fundamental dishonesty without the need for oral evidence or cross-examination. The claimant, Mr. Gosling, having discontinued against D2. Now, the key case on Section 57 fundamental dishonesty is the Lacog and Lindfield case, and that was a decision of Mr. Justice Julian Knowles. And you have there the definition that he gave of what fundamental dishonesty is under Section 57. He said that it was if the defendant proves on a balance of probabilities that the claimant had acted dishonestly in relation to the primary or related claim, and that he had substantially affected the presentation of his case in respect of liability or quantum in a way which potentially adversely affected the defendant in a significant way, judged against the context of the facts and circumstances of litigation. Now, you might think, and I'd agree if you did, that's a pretty wordy definition. The essence of it is, if, as to liability and quantum, the claimant substantially affects the presentation of his case and it will be to the defendant's detriment, then that is fundamental dishonesty, judged against the backdrop of the circumstances of the litigation. And the test as to dishonesty is as it was set out by the Supreme Court in Ivy and Genting casinos. And as to what Mr. Justice Julian Knowles thought was the fundamental dishonesty in that case, he, the claimant, had broken his left arm and claimed for gardening expenses. As a result, his case was that he'd broken his left arm and his wrist and needed to employ a gardener to carry out gardening work, which he otherwise would have been able to. He claimed substantially for gardening expenses, which were about 42% of the total special damages and about 28% of the claim for special and general damages. The defendant approached the gardener. The gardener said, that's not true. I hadn't been engaged to do the work which the claimant says I had. And unsurprisingly, you might think, Mr. Justice Julian Knowles said that's fundamental dishonesty. The more recent cases, to give you an idea of what is and what isn't fundamental dishonesty and how the tests are applied, are these. Elgamal and Westminster City Council, and that's a decision of Mr. Justice Jacobs in the Queen's Bench division recently, where it was said that exaggeration of injury is not necessarily fundamental dishonesty. There, the claimant, then aged 22, had injured his knee on equipment at the defendant's gym. They accepted 65% of liability, but disputed the claim for quantum. And he had suffered some loss of movement in his knee and was unable to work in work which involved very heavy lifting or kneeling. But they commissioned surveillance of him, and it showed that he could walk normally, but that he had a noticeable limp when he was examined by the experts at around the same time. So you might think the same kind of thing that was going on in the Gosling case. The judge held that the claimant had believed that he was disabled to a greater extent than the judge had found that he was, but he'd exaggerated the ongoing effects of very serious injury. And Mr. Justice Jacob said you have to take the test in two parts. Is there dishonesty and is it fundamental? And he found that that exaggeration was not fundamental. And so the claimant hadn't been fundamentally dishonest. Michael and Ian Herdford, and another High Court decision, they typically, fundamental dishonesty trials tend to be some county court decisions, but the most recent raft are typically High Court decisions. This was a credit hire claim. And the claimant in cross-examination said that he had also, in pursuing a claim for the cost of physiotherapy treatment, didn't understand the claim for physio and had accepted that he had a second part-time job, impecuniosity being one of the issues in the case, but that he told his solicitors with all the required, that he had informed his solicitors of that, and he gave them all of the necessary credit cards and bank statements to that effect. But he couldn't understand why the evidence wasn't before the judge. And the first instance judge said that that was not basically fraudulent, and so none of it was fundamental dishonesty. He also said that whether the claimant had been dishonest or not was a matter for the trial judge. Walkden and Draco Manor Park, a case of colleague Andrew McLaughlin's in Chambers, Mrs. Justice Tipples. Mr. Walkden, a company director, was injured on a gondola at Drayton Manor Park. He said he suffered a severely disabling chronic pain syndrome, which had caused the loss of his business and the need for daily care and assistance from his wife. The judge awarded him a bit more than 17.5 grand as against a claim for 1.5 million. And Mrs. Justice Tipple said that His Honour Judge Murdoch was more than entitled to find that that level of exaggeration was fundamental dishonesty, and the fact that there hadn't been a reference to FD in the judgment didn't preclude a finding on a subsequent application by the defendant. Smith and Haringey, there was no dispute here, a trial before Master Cook, as to the accident and the fact of an injury, that the claimant assaulted by a service user with learning difficulties, and the judge found there was no doubt that she continued to experience pain in her spine and pelvis at the time of trial, against the background of a claim for general damages and loss of income of a bit less than £625,000, so a heavy claim. But the ongoing pain in the spine and pelvis had nothing to do with the accident and everything to do with a degenerative condition, about which both sets of experts had agreed, the claimant having parted ways with her solicitors. So the judge there had little difficulty in finding that the attribution by the claimant of pre-existing pain to a breach of duty was fundamentally dishonest, where the claim was for £624,000 in total. Pagan Web, we are nearly there. The claimant, a front seat passenger in his car, which collided with the first defendant's car, and a week or so before then he'd been involved in a quad bike accident. A relatively modest claim for general damages to numerous parts of the anatomy and physiotherapy charges of 426 quid, liability admitted. The claimant, didn't go and seek any medical assistance after the accident. His solicitors arranged physio. He'd gone to A&E after the quad bike accident, but didn't tell the doctor of the injuries sustained when he was examined for the purposes of the collision. That and the fact that he didn't tell his medical experts of the quad bike accident, another cause for his, what he said were accident attributable injuries, were two lots of deafening silence, Mr. Justice Martin Spencer said. So pulling it together, what do you have to look out for? Well, I've set it out here for you. What do the pieces of documentary evidence say or not say? What does the evidence which is supported by a statement of truth say? What is said in a document, is it supported by the other evidence, or is it contradicted by the other evidence? So that is to say, does the evidence in the witness statement or the schedule of loss, is it corroborated by the other evidence? Surveillance, what do you think it shows, and what's the judge's likely overall impression of it? How large the claim is. Has the claimant made a claim for personal injury compensation before? Is there an organic or objective explanation for the injury? Is it a corroborated account? Is it a claim that sounds so large as to be inherently inflated? Is it the kind of amount or the kind of claim to which you would raise an eyebrow to? And timing of conferences, I think, is always helpful here. early from on after first instruction by the client, if there is or is likely to be an allegation of FD made, and certainly if for a claimant after the defendant has revealed the key parts of its attack, are likely to be the two key points in a claim where you're making or meeting an allegation of FD. And advice from counsel at either or both of those stages is likely to focus the advice that you will be able to give to the client. So that, in relatively quick time, is what I wanted to say about fundamental dishonesty and the recent cases that give a flavour of it and the practical advice that follows from it. So thank you for listening to me.
Next, we have John Lindfield. John, are you able to share your screen?
I am indeed, Mark. I was waiting to see whether we were going back to you in between us before switching everything on and getting going. Yes, bear with me one moment and I shall attempt to share my screen. He says not being able to close the have opened. Apologies for this, we will get there eventually. There we go. I assume that is working properly. So I will kick off then. Yes, thank you very much for having us this afternoon. And thank you, Mark, in particular, for describing us as amazing barristers. That's going straight onto my Chambers profile on the website. Yes, so moving, I suppose, from liars to mistakes. This is a talk in two halves, really. The first is about making mistakes in the portal, and the second is about some less encountered but things that is often worth having a revision on with respect to costs in the portal. Before we start, I suppose, to say, what do I mean by the portal? Anyone that's done any cases involving the portal will know what I mean is the RTA portals, and in fact the ELPL as well. I think, but I don't know because of its recent inception. But it's likely, it seems to me, that these sorts of arguments could be run under the new portal with respect to low value road traffic claims for reasons that we'll get onto. But in effect, so the first part of this talk I've called costly mistakes, and that's for a reason, because there is a raft of, I say authority, no higher than appeals in the county court to a large extent but cases nonetheless that have been relied on in subsequent cases of people making mistakes during the portal and being held to them. Now, depending on whether you are a claimant or a defendant or your view on litigation generally, you will either, at the end of this, think that the decisions the court have reached are perfect and a good application and robust application of the rules as they are written, or something approaching injustice. What I'm talking about then is what mistakes you could possibly make, going on to how to avoid them, but then what to do if you have made one. As I say on this slide, mistakes in the portal are all too common. I'm sure anyone that has been dealing with any portal cases at any time knows how easy it is for things to be overlooked, the wrong buttons clicked, the portal itself to fail, the system to fail. But they can, if left undealt with, lead to consequences that you might not intend. So what mistakes am I talking about? I say big ones. What I mean is potentially big mistakes, for reasons, again, we'll come on to. But largely what we're talking about is either making the wrong offer at stages 2 or 3, and or clicking the wrong buttons at some point. There is another element to this, which is the gross offer box in the stage 3 process, which I'm sure all of, again, anyone that's dealt with these cases will be aware of. Now, it was my intention on the next slide to have a picture of the stage 2 settlement pack. I assume, though, that anyone who's worked with it knows what I'm talking about. What we've got is a series of boxes where you can input what your claims are, or in fact what your sort of counterclaim is, your counter offers are, for various heads of loss, including medical expenses, personal injury, etc. Further down the page, it gives you the option to make a gross offer. Now, I will take it as read from here that gross offer box can be made, and it's something that we will see judges have found can be made to make independent offers that are independent of simply adding up the other heads of loss that are being claimed thus far. But perhaps best to start with an example, and this is the most straightforward example I can think of. For example, let's say that claimant claims a PSLA, again within any portal as they currently stand, at 12.9, physiotherapy at 500, but they put 12,000 in the gross offer box. Defendant receives that offer, makes whatever investigations they want to make. They reply saying 4,000 for PSLA, and two. That shouldn't say PSLA again. That should say physiotherapy. But accidentally repeats the claimant's gross offer back to the claimant. So they've made what totals £4,200, but in their gross offer seem to suggest that they are making a counter offer of £12,000. The claimant goes ahead and says, yep, thank you very much for your £12,000 offer, we accept. Now, what would you expect in those circumstances? Well, in lots of particular cases like this, the claimant would be held to their mistake. Now, on this slide are 3 cases. There are in fact many more, but I pick these out as those that have been largely relied on in the main, where the issue of whether mistakes can be relied upon has been upheld, i.e. no, you can't rely on the common law doctrine of mistake. Now, examples these are, so Draper and Newport, a case where the claimant's solicitor accidentally accepted an offer the defendant had made they had no authority to accept. Claimant then sought to say that was a mistake, it was a unilateral mistake, I didn't have authority to accept it, please set this aside. District Judge Baker said no, there is no common law doctrine of mistake in the portal, and you will be held to your mistake. The second case on this slide is Fitton and Aegeus. Now, this was an appeal in the County Court. His Honour Judge Parker. This is a little bit more like the example which I wrote in the previous slide, but it was a little more involved in terms of this had gone back and forward a couple of times. But in effect, what had happened is claimant had made their offer, defendant had made their counter offer. The claimant went to make a further offer, but accidentally reflected, again, the gross offer back at the defendant. Now, in those circumstances, the defendant said, thank you very much for your gross offer, we accept. And just at this stage, as to what the courts have been saying about this issue, just that quote from His Honour Judge Parker, the offer had been made by the claimant, albeit mistakenly, and the offer was accepted by the defendant, as the defendant was entitled so to do. Whether there was a meeting of the minds between the parties did not matter. And these are the sorts of things that are surprising, perhaps, if you've not encountered this problem before. How far that doctrine goes, I say, you can see in the case of Maloney at the bottom of the page there, again, only the county court, but have made their way onto the public forum for because of these issues. Again, the claimant held their mistake when intending to write £5,500, writes 550. Again, the court holds claimant to their mistake, saying it doesn't matter that you didn't mean it. Now, that probably raises some eyebrows or causes hearts to leap up into throats, because we've all, I'm sure, been in the situation where we think, we hope that we haven't put an extra zero, or in fact not one too few zeros on the end of any figures. So the first question that comes to mind when looking at all of these decisions is, why have these decisions been made in this way? Now, the reason why, and it's important to know why in these situations, is because it has been decided by numerous judges at various levels that the protocol exists to the exclusion of common law principles, for example, the doctrine of mistake. The first case that I've referred to here, Purcell and McGarry, His Honour Judge Gore, well, he's not retired, His Honour Judge Gore, but when he was sitting in Liverpool County Court. Again, not to quote from judges at length, but what we can see is he says here, in effect, that the RTA protocol is a freestanding series of rules into which common law principles should not be inferred. Now, that is for a number of reasons. In fact, that case, Purcell and McGarry, is a good place to start if you want to be arguing things like we can accept offers out of time. I say in quotes, what I mean is outside the consideration period. His Honour Judge Gore effectively says here, there is no sort of common law doctrine of offer and acceptance in the same way. Unless you have explicitly withdrawn an offer, they remain open for acceptance. So that's the starting point, is you accept as a starting point that the protocol exists in its own sphere. You don't import any common law rules in. And that leaves you in the situation where there is no room for a mistake. If you type the wrong number into the box, you are following the structure of the protocol as it is written. Unless you have taken any further steps, you will not be able to rely, those cases say, on the common law doctrine of mistake by saying, there was, this was my mistake. It was obvious it was a mistake. The courts have been slow, and certainly in my experience, when I've had some cases that deal with these issues, courts slow to accept that on the basis of these cases. Now, the other reasons why the court has said that it exists to the exclusion of those principles are things like that it undermines the certainty of the protocol. It is the view of the judiciary, certainly that have grappled with these issues, that the protocol is sufficiently certain, such as to enable parties to know exactly what they face through the lifetime of a case that continues within the portal. They know this will be done by this date, that will be done by that date. This is how you calculate your offer. This is what you put in this box and that box, and so there is no room for any misunderstanding. Again, linked with that is the idea that both parties benefit from the tight reading of the rules. Claimants benefit because it is a easy, quick process by which hopefully claims can be dealt with expeditiously and without recourse to the long court process. It can be done online. Defendants benefit because it is low cost. Defendants can make early admissions and keep costs down from the start, knowing that they will be fixed in the event. And number 4, everyone's favourite reason for the courts doing anything is, they say, eliminate satellite litigation. And if you were to go and read either Fritton and the GS or one of the cases I'm going to come on to, the courts are very keen to restrict the fact that a case that in any of those cases, for example, Fitton and Aegeus, we're talking about £3,900 versus £2,500, and that had been subject already to an initial first hearing, a permission hearing, a hearing in front of the circuit judge. And again, the idea is that what they're saying at this stage is that the certainty outweighs anything else. There are a couple of other cases. There's one called Zommers and Litham. That's District Judge Johnson. Again, a slightly more stark difference here. That was the difference between £23,000 and £13,000. Liss and Rogers, again, perhaps even more stark. That case, claimant wanted to request an interim payment of £1,000, accidentally made an offer for £1,000, which was accepted, and they were in fact held to that offer. And now, my slides won't move forward. There we go. So, once we know that mistakes are bad and you can be held to them, the answer is how to avoid them. Well, District Judge Baker's view on this was the solution to that was, quite frankly, to be simply more careful in the way that she, that is the solicitor that accepted the offer without instruction, operated the system. Unhelpful, probably, in that mistakes necessarily happen even when you're taking care. These things happen. Fitton and Aegeus, His Honour Judge Parker again says, insofar as one party may make a mistake in dealing with the process from time to time, the benefits of the system outweigh the negatives. So again, that's another judicial view that says mistakes are going to be made, so be it. Be more careful. And that, I suppose, could leave anyone feeling a little dejected in that, oh, no matter what mistake I make, however in good faith I operate, I'm going to be held to this. So what I say is there anything a bit more helpful to anyone that does make a mistake? And there is, albeit for reasons that we'll come on to. It is equivocal help, I suppose. The case of Harrison Brown, His Honour Judge Davey QC, sitting in the Bradford County Court. Now, in this case, everything had gone right. The claimant made an initial offer totaling just over £12,000. Defendant countered just under £6,000. The claimant managed to then counter, but used the same figures because they said we're not budging. Defendant responded, increasing their offer on things like physiotherapy very slightly and making an increased global offer to match that. The claimant then countered, reducing their PSLA claim, maintaining just around about £12,000-ish worth of claim, but then made the mistake of reflecting the defendant's global offer back at them. Now, in that case, it was said that there were problems with the portal. The actual system had failed to the extent where the claimant solicitor said she could not amend the global offer figure. And that is important for two reasons. One, anyone that works with the portal will know how often it fails. But secondly, it proved important that the claimant solicitor did something about that when it was identified that a mistake had been made. Now, what happened in that case, and as you'll see at the final bullet point, is that as that claimant offer went in, an email was sent at the same time as the offer, or with the offer, making it explicitly clear a mistake had been made, providing a breakdown before the defendant sought to accept that offer. And for those reasons, His Honour Judge Davey went on to say, and you'll get a copy of these slides, so I won't read it out in full, but the piece that I will focus on is, he says, rough justice there may be, but on a continuum of roughness, moving through rougher justice and roughest justice, there must eventually come a point where the justice is so rough that it becomes injustice. And you'll see that he says that that is the case on the particular facts of this case. Now, that resulted in an appeal to the Court of Appeal. Permission was in fact denied. Lord Justice McComb says, I reached this decision with no regret whatsoever, so avoiding what would otherwise be a monstrous injustice. The reason for not giving permission was largely down to the fact that His Honour Judge Davey had made quite explicit in his judgment as to how restricted it was to the particular facts of the case. But certainly, if one is looking for authority as to the point of the judicial view as to mistakes being made, and the other side should know that there's been a mistake, then the Court of Appeal's view on that you've got there. Certainly, then, the takeaway points from this: be very careful not to make mistakes in the first place. I say that as honestly and with good faith as I can. Mistakes obviously will be made. So if you do make one, tell the other side as soon as you become aware. Make it clear it was a mistake. Use those words and present that to the other side, whichever side of the coin you are on, before they accept it. I suppose if you're on the end of a receiving end of a mistaken offer, at the moment, take it. If there's nothing you've received that suggests this is a mistake, the cases would suggest, albeit as I say, this is no higher than appeals in the county court, that you should take it, and there is no doctrine of mistake. Ensure the judge at the first instance deals with the overriding objective. I say that because one of the reasons that Harrison Brown, His Honour Judge Davey, found as he did was because the judge at first instance did not deal with the overriding objective. In fact, His Honour Judge Davey agreed that there is no importation of common law doctrine into the portal. He didn't allow the appeal on those reasons. What he said was, we need to deal with the overriding objective. First instance judge didn't. So if you're doing this at first instance, make sure the judge deals with it. So that is two sides of the coin when it comes to making mistakes. It seems as though in the large, and certainly the cases I have dealt with, you will be held to your mistakes if you make them, unless it had been made very, very clear that a mistake has been made. So those were the takeaway points from this side of the talk. Now, a very brief overview, and I will make this brief because I'm conscious of time. Some costs points during the stage 3 process that are often missed or overlooked or misunderstood. Firstly, remember that you get more costs if the case is worth over £10,000. That is on the RTA protocol. All too often, we see schedules of costs or whatever just going into robot mode and repeating the same fixed costs as for under £10,000. But remember, you get more. You also get more if it's an ELPL case, so make sure you've read your tables and make sure you've got your schedules lined up with respect to that. The cost of counsel's advice for children is built in. That is your type C costs. All too often we'll see schedules claiming that separately. No need because it's built in. Some disbursements which are allowed but often disputed unnecessarily, things like DVLA checks, engineers' fees. All of these are allowable disbursements. Remember, these are still fast-track value claims, albeit proceeding in the portal. And remember to include your disbursement vouchers where anything is disputed. A number of times I have seen judges who will say, well, this has been disputed. I haven't seen a disbursement voucher for these things, especially if it's going to be one of the less encountered things. Remember that you're not, this is both for defendants and claimants, it is not always a fixed fee medical report. Again, this is largely within the RTA sphere, does not apply in a number of circumstances, for example, children, pedestrians, motorcyclists. All too often see the costs of those reports disputed because they are in excess of £216, but they don't have to be. The same goes for any higher discipline or those not listed specifically by the rules. And there is just a brief summary there of the Part 36 consequences. It's no more than a repetition of what you see in the CPR, but things to make sure that you have looked at in advance if you think there's a realistic prospect of the offer being in the portal. So I believe that is everything. So, as I say, costly mistakes and mistakes about costs, why you shouldn't make mistakes, and things to look at with respect to costs going forward. I believe we're going to mop up questions at the end, so I will leave it there and say thank you very much. Hand back to Mark, who I'm sure will hand you over to David. So thank you very much.
Thank you very much, Jonathan. While David is setting up his slides and so you can see his screen, just want to remind you all that there is the Q&A box function. If you have any questions, please make sure to put them in there and we will be dealing with them all at the end. And I shall pass you over now to David. Thank you.
Thank you. Mark, can I just confirm that you can see the full width of the slide on your screen?
Yeah, I can see that all fine.
Brilliant, thank you. Well, yes, hello, I'm David Forster, personal injury barrister. I started my pupillage at St John's 3 years ago in October 2018 and have been on my feet since April 2019. During that time, I've been involved with probably hundreds of portal claims and stage 3s and dozens of fast track trials and disposals. So why talk about care claims, or rather, what's this talk going to be about? It's not going to be about the legal or appellate history of care and assistance claims, how we arrived at where we are today, nor the concept itself or what important questions we've got. You know, we're not talking about whether the House of Lords were correct to hold that you can't claim for a care provided by a tortfeasor, or the advantages or disadvantages of holding care claimed money on trust. My hope is that this short talk will provide some practical tips on how to make an effective and efficient claim for care and assistance, typically in portal claims, thinking soft tissue RTAs or the sort of the lower value employer's liability or public liability claims that start in the portal. Hearings, it's my view that care and assistance is very much underclaimed within this process. I've seen many times where claimants and their representatives have missed opportunities to claim for something for which they're almost certainly entitled, giving an unnecessary windfall to a defendant insurance company and leaving their claimant out of pocket for no good reason. Think about the typical pattern, the fact pattern of a soft tissue RTA claim. Usually what you're going to have is when symptoms are at their worst, and claimants are sometimes quite significantly restricted in what they're able to do. This is then followed by a longer period where symptoms are said to have reduced to a nuisance level and the claimant is no longer as restricted as they once were. Now, there is often evidence within those claims, or it's very strongly suggested by the evidence in those claims, that the claimant did require and did in fact receive some care and assistance during that initial period post-accident where symptoms were at their worst, but we see that no claim for that care has been made. This is also true, think of your sort of simple orthopedic injuries that normally pop up in employer's liability or public liability cases. Think broken wrists, broken ankles, or maybe a period in time where the claimant is in a plaster cast or having to use crutches, following which we get that sort of longer period of rehabilitation. And it's mad, in my opinion, that we have a claimant who, for example, has one of their limbs immobilized or in using crutches cannot carry things and walk at the same time. It's mad to think that that person did not receive some care and assistance during that period. So what do you need to look for at the start of the claim when you're thinking about care and assistance? Well, you don't have to wait for proper formal instructions from the client or a proper conference with the client to discuss the issue of care. Most clients or claimants aren't going to know that they can claim for that. What you should be doing as their lawyer, look at the medical report. Typically in your RTA soft tissue injury claims, it's going to be a GP expert who has examined the claimant, and you want to be looking at what has your client told the examining GP. You want to, when you get to the section that deals with loss of amenity, often called the consequential effects or the effects on daily living, sometimes within that the expert may expressly say that the claimant required and received unpaid assistance during the initial period after the accident. If so, that's great. You can then get on the phone to the claimant and say, well, you told the expert that you received some care. We can claim for that. let's get the details of that down. But most of the time, what you will see is that the expert will mention the activities which the claimant was restricted in following the accident and the level to which they were restricted. You are looking, when you're doing that, you're looking for examples of aspects of daily living, personal care, that sort of thing. On to the next slide. This is a copy and pasted example from a stage 3 hearing I think I did last week, where you can see the sort of detail. Note that it says severe restrictions in personal care and the various domestic activities. If you see something like this in the medical report, you can get on the phone with the client and say, look, you told the expert that you were severely restricted in that initial period with these sorts of tasks. Did you receive any help from another person in order to do these? And if they say yes, then you say, great, well then you can claim for that and you get on to getting the details of that down. Now, if the medical evidence does not mention any assistance or any sort of severe or significant restrictions in the activities of daily living, there are some claimants who, you know, they're only restricted in heavier activities such as playing sport or attending the gym. If you don't have any reference to unpaid assistance or any significant restrictions in day-to-day activities, then you don't really need to explore it any further with the claimant. What you don't want to be doing is putting forward a care claim that in fact conflicts with your medical evidence. You want to avoid any conflict within your own evidence as much as possible. The next question is how to evidence. How to properly evidence your care claim, and the answer is incredibly simple. It's a witness statement. If you are within the portal, that statement need not be very long, and it can be a simple pro forma, something that is largely pre-written and that has gaps for you to fill in following a conversation with the claimant. Once you've confirmed that some care was provided, it need be no more complicated than saying, well, for X number of weeks, you've got a box there to fill in. This person, identify them, Mrs. Jane Smith, relationship to the claimant, my mother-in-law, provided care and assistance at my home as I was unable to manage due to the symptoms suffered in the accident. Mrs. Smith spent X hours a week helping with this, X hours a week helping with that, cooking, cleaning, that sort of thing, and X hours a week helping me with my personal care. This then stopped at X number of weeks, 6, 8, 12 weeks after the accident, as my symptoms had improved and I was able to manage. Talking about statements, ideally you would want a statement from both the carer and the caree. Again, it ought to be fairly simple to adapt that one statement into two, just sort of adjusting the perspective on it. But it's far from the end of the world if you can only get one of them, especially if we're still within the portal process. Judges will usually consider a witness statement signed with a statement of truth as good evidence at a stage 3 hearing. And keep an eye out for instances where the carer lives outside of the family home and has had to travel to provide the care. That in itself can be quite strong evidence that care was reasonably required. So, what to claim for? Again, when you're thinking about this, you just need to think about what's in the medical evidence. What has the client reported difficulty having with to the expert? That will provide the scope of what you can claim for in the care and assistance claim. You can see there on the slide the typical sorts of activities that fall under these headings of personal care and domestic assistance. Very common for someone who's sort of suffering with a soft tissue whiplash injury with symptoms in the neck and the shoulder and upper back to have problems with dressing, bathing, or applying or doing hair in the morning and that sort of thing, or doing the heavier domestic tasks. Moving on to the next slide. When you're doing it, again, keep it within the scope of what the medical evidence says, but do keep it sensible. We're not talking about sort of everyday, then perhaps there might have been a slight adjustment in the balance of chores in the household between spouses. It really has to go sort of over and above that. For example, I can give you an example of once I was defending in a case where care was being claimed because the claimant's husband wanted to claim for the extra time that he had had to spend entertaining his children and leaving their house earlier than he perhaps otherwise would have done to take his children to school. My response for the defendant, which was echoed by the judge, was sort of, well, boo-hoo for you. That's just part and parcel of being a parent and does not amount to providing over and above the normal level of care and assistance for your family. But on the other hand, as I've already touched upon, if you've got evidence of an outside carer travelling to provide care, that in and of itself is good evidence that the care was reasonably required. We then need to think about the hours. Again, keep this as reasonable as you can. If you've dealt with these sort of PI cases before, your experience will likely have been similar to mine, that people are often completely innocently, but also totally wildly inaccurate when it comes to their estimation of time. People will tell you that it takes them 5 minutes to cross the road, or 30 seconds to move from their sitting room to their kitchen, or something like that. So don't be afraid to challenge your clients on this. Think to yourself, how long would a certain task reasonably take? The risk of overstating the amount of hours of care provided, the most severe risk, not the most likely, but the most severe risk, is that you could discredit the rest of the care claim and damage the claimant's overall credibility. But the much more likely risk is that the judge will recognise that there's been an overestimation of the time of the amount of care provided, and will sort of take a hatchet and apply a sweeping and unscientific discount to your care claim, and make a heavier discount just to be on the safe side, because there's no time in these shorter hearings for sort of detailed discussion or submissions on these points. So you could end up with a figure much lower than if you had pressed the client to keep it within reasonable limits. So we've got the evidence there. The next question is pleading. Again, relatively straightforward answer here, a short, punchy schedule of loss. Again, this can be on the basis of a pro forma, and it just needs to be a breakdown of, it was X number of hours a week on this element of care, X number of hours per week on this element of care, and so on. This is my total hours of care for the week. This is the number of weeks that we're claiming for. You get that evidence from the witness statement. And this is the hourly rate that we're claiming for. We'll touch on that in a second. It's vital that you put the calculation in. I have seen it many times where, you know, the claimant solicitors will have gone through the first stages of providing some evidence of the care, but then we'll just put a number in with no calculation to tell the court how it's been arrived at. And again, open yourself up to the whole thing being knocked out, or again, the hatchet comes out again and this great big sweeping discount could be applied. So a schedule of loss to be served with the documents. If you can, copy and paste that into the comments box of the portal, so it appears at stage 2 and in the court proceedings packet at stage 3. The next thing to think about are the rates. Now, there are published carer and nursing rates that appear in one of the sort of PI practitioner handbooks, Facts and Figures, the annually published book. However, in my opinion, when dealing with the type of claims that we're talking about here that remain within the portal, they are unlikely to be appropriate for this level of claim. Claimants aren't receiving specialist nursing care or any sort of occupational therapist input. The level is often going to be quite basic, so that the claimant wouldn't be paying those enhanced specialist rates in any event. And again, when you're dealing with the portal, I appreciate the workloads that people are under. It's unlikely to be worth your time ploughing into that resource, going through all the tables and working it all out. You can see what I've done here, and I suggest, what I recommend doing the same, is to Google what was the minimum wage at the time. You see here I put it in at £8.91, that's from May 2021. You would be justified in making a small uplift here if you wanted to. You could go to £9, £9.50, perhaps even £10. But it's difficult for a defendant to argue against a rate that is at or close to the minimum wage rate. The other thing to keep in mind is that a discount will always be applied to care that has been provided gratuitously by a family member or a friend. there is in fact no hard and fast rule for this, but most judges, most district judges will recognise 25% as being the typical standard across the board reduction for the gratuitous nature of care. So you can see at the absolute minimum here, minimum wage, that produces a rate of £6.68. What I've got on the next slide is a very basic example, all pretty typical stuff that you might see in a stage 3 claim. You have a 36-year-old female, a homemaker whose husband goes out to work and she cares for 2 young children, 6-month multi-site whiplash with 6 weeks of severe symptoms and severe restrictions in the immediate aftermath post-accident, and her mother travels to provide care with her personal care and various domestic elements there as well. And then we can see again on this slide, it's all relatively modestly claimed. 3 hours per week on personal care would equate to sort of just over, well, would equate to half an hour a day for 6 days per week. An hour per week on shopping is pretty self-explanatory. 4 hours per week on cooking and cleaning, and 2.5 hours per week on the heavier aspects of childcare, for example, putting the children through the bath or getting them to bed, tidying up the heavier toys and that sort of thing. But it all adds up. It's all consistent. If you think back to that box we had from the GP report earlier, with these activities being severely restricted in that initial stage, it could all be evidenced quite simply with that pro forma statement and the pro forma schedule. But you can see how it all adds up, and you end up, even at this lowest rate with this modest claim, increasing your client's claim for personal injury fairly significantly, and then hopefully you have a happy client at the end. Another thing to consider here is that if your claim is within the portal and you followed this advice and you've come to a stage 3 hearing, or you're approaching a stage 3 hearing with this witness statement and with a nice punchy schedule of loss, the claimant is in a very, very strong position here, because witness statements can form part of the evidence of a stage 3 hearing, but no oral evidence is permitted. So if the defendant wants to challenge this evidence through cross-examination, for example, they would need to effectively pull the claim out of the portal and allow the claimant to start it again, to start Part 7 proceedings. But doing so would greatly increase the fixed costs that the defendant would have to pay the claimant. So there is a really strong disincentive for defendants to pull claims out of the portal. And so if you can turn up with this fairly easily evidenced care claim, then the likelihood is it's going to go through unchallenged. Even in claims that are already proceeding under Part 7, so you're already out of the portal, the way that the fixed cost regime works, again, it actively incentivizes defendants to settle claims prior to the trial, because the fixed costs go up at every stage of the proceedings, and obviously most expensive at trial. So again, the defendants have that incentive to settle, and if your care claim is consistent with the expert evidence from the GP or the orthopedic expert, whoever it may be, is properly evidenced within a witness statement, and is realistic in its scope and in the amount claimed, then you've got a much better chance of securing higher settlements for your clients, even in claims that are proceeding outside of the portal. So that is my advice. Hopefully, like I say, a few helpful practical tips to help increase the value of claims and how to do this as efficiently as possible. Next slide, I think. Yes, any questions? I understand we're doing that at the end. The full screen function has blocked my clock. Oh, only 2 minutes over. Hopefully that hasn't caused any problems. Mark.
Thank you. Yes, we'll just run through the Q&A. I know we're meant to be finishing at 2, so we'll just run through a couple of questions quickly with the speakers, and then we can let everyone get on with the rest of their day. I guess we should start with the first question we received. In Patricia Smith's case, this is for you, James, by the way, fundamental dishonesty. Was that not the claimant's opinion rather than an assertion of fact? Were there any overlap between the degeneration and actual injury?
I've rechecked the judgment, Mark and Mutahar, and the answers to both of those questions are No, or probably not. That is, claimant saying, I had a problem with my lumbar spine and pelvis as a result of an accident. And was there any overlap between the accident, or what the claimant said was pain caused by the assault, and her degeneration? And Master Cook said no. And just Mutahar, if you want to, that I'm getting that answer from paragraphs 46, 47, and 66 and 67 of the judgment for you. So in short, no and no, I think, are the answers to your questions.
Brilliant, thank you. A question for Jonathan Lindfield on portal mistake costs. If, when attaching evidence to the portal when making a stage 2 offer, the claimant solicitor do not attach the medical report invoice, but do attach the medical report itself, indicating there is likely to be a disbursement, can the defendant refuse to pay the invoice once the claim is settled?
Can you attempt to refuse to pay it? Yes. Would I expect you to be successful in doing that? Probably not, unless it's an unreasonable figure that's later claimed, or I suppose if it's an unusual expertise. 9 times out of 10, what we're talking about is a GP report. We know that they're fixed costs. You know that the claim is entitled to it. I suppose this links in with the last question on the list that deals with costs. If I might do that at the same time, if only to say the doctrine of mistake we are talking about is quite literally putting these things in boxes and having that being answered. It's not quite the same as the costs argument that follow. The rules I don't believe specify particularly you need to set your costs out, etc. I know that there is a space on the form to do it. I wouldn't imagine it to fall in quite the same way, and I wouldn't expect you to be successful in front of a judge arguing that you shouldn't have to pay for a report that you've had on the basis that you haven't had an invoice. As I say, maybe a bit different for those unusual disbursements. Always better to get your disbursement vouchers in. If you haven't got them, if you're for a defendant, I would say the best advice is ask for them first, so you can't be accused of doing anything unreasonably and ambushing it on the day.
Brilliant, thank you. I think it might be useful to jump on. We had one near the end on the chat functions there for David. In the care example, would you claim for mother's travel time and travel expenses to the daughter's house?
In my experience, this has proved somewhat tricky at stage 3. You do sometimes see carer travel being claimed, and you can get into arguments about, well, you know, whose loss is being claimed for. My advice, if I was doing it, would be to roll it into the time spent. So if the mother is saying, right, you know, I have to go over and help my daughter do this, with total time it took me, including travel, was 2.5 hours, and then you can apply that rate. That's how I would recommend doing that.
Brilliant, thank you. A quick question for James. When and how should the defendant raise fundamental dishonesty to successfully pursue it and avoid accusations of ambushing the claimant?
The answer to this question is in my slides, but for reasons better known to me, Mark, we jumped over it. The case that I'm not sure why I think my down arrow didn't catch up with when I was pressing it. Howlett and Davis and Aegeus, a 2017 decision of the Court of Appeal, and Lord Justice Newey giving the leading judgment in it, is the case on this. The short point is, for that case there, Aegeus said they disputed the happening of a road traffic accident, or if there had been an accident, they said it was a low velocity impact that couldn't have caused injury. And the district judge found that Mrs. Howlett, the elder, and her son, the younger, to have been fundamentally dishonest. The Court of Appeal said, as long as you've pleaded the facts from which the court can make the direct finding or draw the inference as to dishonesty, that's all you need to do. So and that the claimant has, or the witness has had an opportunity to deal with the possibility of a finding of fundamental dishonesty, that their honesty is an issue. So short point, it should be pleaded in the defence in a way that allows the court to make findings which then lead on to an application for fundamental dishonesty. So the answer in short is, I think it needs to be in the defence. The defence is the document which will give you an idea as to whether a defendant's running FD or not.
Brilliant, thank you. I think since we're already 10 minutes over, it'd probably be a good idea to call and end the session there. If anyone has any questions, I'm sure they'll be able to find your details and contact you regarding the slides. But I think it's probably a good idea to let everyone get back to the rest of their day. I just want to say thank you to the three of you for a fantastic talk. That was amazing. And for all the participants still on, just to say that, you know, please do follow the Bristol Law Society and to make sure you stay up to date with events that we have running up, and hopefully we will see a few of you at the BLS Ball next week. Thank you very much.
Thank you, Mark. Good afternoon.